it is kind of uncomfortable. You get kind of stressed out. If you don't want a big lawsuit on your hands afterwards, I mean, you want to keep the money you're getting, right?
Of course. And we are back to Business Law Toolbox. In this episode, we're going to keep on talking about the 5-step when selling your company, the M&A process. And we're heading out to step 3, which is the due diligence.
Yeah.
The most important part, I guess.
Well,
if you want to know everything about the company.
Yeah. So the due diligence, we have number 1, the NDA, right?
Yes.
About sharing information. And then we have number 2,
which is the term sheet.
Exactly. The non-binding, about the general terms and conditions about, so we're kind of in agreement.
Yes.
We kind of have a direction.
But some parts were binding, which we are talking about in the previous episode.
That we will link to.
Yes, of course.
Perfect. And now, when we have that general agreement, I, as a buyer, will want to know everything about the company.
Like everything.
Everything. And that goes back to the principle caveat emptor. And that means buyer beware.
Okay.
Because you're buying the company at your own risk. So if you're buying that company and you do not know that it has tax liabilities or a big lawsuit or something like that, it will be your responsibility.
Okay, so buyer beware is when you take the risk as a buyer and everything that comes with the company stays on you.
Pretty much.
Okay.
I mean, not if it's been fraudulent or something like that, but basically, like if you're buying an old car, you want to kick the tires.
Yeah.
And that's the due diligence.
So, what is the first thing you should think about when doing a due diligence? What do you want to know? I mean, exactly.
Yeah, typically you divide it into 3 major parts, which is the financial, the legal, and the commercial. And apart from that, you can do millions of due diligence. Okay. You can do environmental, IT security due diligence, whatever you can come up with. Okay. But those are the 3 major.
Like the most common parts.
Yeah. And as a seller of the company, it is kind of uncomfortable.
Yeah, I can imagine. I mean, you need to open up all the books.
You get kind of stressed out. And if you're a first-time entrepreneur starting your first business, you will have all of the focus on getting it running, making it profitable, attractive, getting the everyday things working. Mm-hmm. So you might not have had the time and the energy to think of all the legal aspects or the record keeping of the finance, everything like that, like in perfect order. And all of that will come up to the surface during the due diligence. Mm-hmm. So typically, it's kind of uncomfortable for you as a seller of the company.
Yeah, and how do you handle that? I mean, you cannot hide anything. If I mean, you don't want to hide anything, because I think maybe it's better to be transparent. But the financial part, let's say if there was something bad that happened, you need to tell your buyer.
Absolutely, because if you don't want a big lawsuit on your hands afterwards, I mean, you want to keep the money you're getting, right?
Of course, of course.
Yeah, then you need to be transparent, because everything you have disclosed and really shown the buyer will be things that are considered to be priced in. So the buyer can't say, oh, I didn't know about this lawsuit, if you're being completely transparent with it. And what you should really, really, really know also, I've been doing this for 15 years. I've never seen a perfect company.
That's good to know.
Yeah. All companies have messed up in some area or some issue, some problem, or some documentation missing. So what you really, really need to do is, like you said, be transparent. Because the biggest turnoff for a buyer, in my experience, will be when somebody does not tell. Because then you get really worried. Okay, so I had to find out this all by myself by putting my legal dogs on you. Then what else will you be hiding from me?
Yeah, and then you talk about other things that you cannot trust the person or something.
Exactly.
But you said the word pricing in.
Yeah.
Can you just explain it? What is it?
Yeah, good question. So everything that I know, everything you have shown me and told me about the company, if I start complaining after I have bought company, I've gotten the keys from you, and then I turn to you and say, you know what? The tax authorities are on me for this and that. Well, if you already informed me about that, then I cannot come and blame you for it because I knew about it, right? But if you kept quiet or even tried to hide it, then I might be able to come after you. And we'll discuss the reps and warranties in the next segment when we talk about the share purchase agreement. And that's super tightly connected to the due diligence. Because you will need to promise that everything that you have not shown me is okay, is in order. There are no other issues that I should know about. So that's why it is so important to be transparent, and for you as a buyer to really be careful and do your responsible due diligence.
So, I mean, if you're talking about pricing in, does that affect the final price at on the company?
Absolutely.
So, if I did something or missed out or have taxes or anything, it needs to be priced in.
Yeah, or it can be in a specific indemnification, which also we'll get into in the next episode, step 4. But that basically says that if I identify a specific risk or issue, a lawsuit, for example, then you can promise that if that happens after I have taken over the company, you will reimburse me. You will pay me for it.
Okay.
Typically, you talk about my watch, your watch. So everything that happens before closing is on your watch.
Okay.
And that's
as a seller.
Yeah. But if you've been transparent again, then I already knew about it. Then I'm buying into it.
Okay. That's good to know.
Yeah. So due diligence, super important and very tightly connected to the share purchase agreement and the responsibility you take on.
Okay. So what about that was about the financial part.
And the legal.
But what's the most common mistake people do when doing this?
From the buyer or seller?
We'll start with the seller.
Seller. Not being ready for it. When we talk about small, medium-sized company. Because the best thing you can do is do a vendor due diligence, your own due diligence, and try to get your books and records in order.
Yeah.
I mean, imagine you're selling your house. The buyer will most likely be okay with you having some kind of dirty laundry. I mean, it's reasonable. You live in the house.
Yeah.
But if he comes in and the first time he's going to look at the house, you have your dirty laundry all over the floor, he will start to wonder, and he will have a hard time seeing the beauty of the house, and he will start to wonder a bit about if you're bringing your A game, really. So do your homework first and fix whatever problems that are fixable before you go to the buyer.
Okay, so that's like the vendor due diligence.
Yeah.
You do it by yourself first.
Yeah.
And then also that can make you more ready to do the due diligence.
Or even if you come with a proper vendor due diligence, the buyer might say, I don't need to do a due diligence. As long as your lawyers and your finance people state that they do the due diligence as if they did it for the buyer. So that they're not kind of doing a selling, but instead doing a proper due diligence. Then the buyer might only want to do a confirmatory due diligence, picking some specific agreements that he wants to look at, some things only.
Okay, so it can be very uncomfortable, which I understand.
Yeah.
I mean, you have to open up everything and it comes to you at the end.
Yeah.
As well.
And my best recommendation for you as a business owner, keep your head cool. Because what can also happen is that when the buyer, he gets this brilliant lawyer and brilliant finance and a brilliant team looking at the commercial. All of them will cost a lot of money, which means that all of them will want to prove that they're worth the money, which means that all of them will want to ask a lot of questions. They want to do findings, and that can be crazy frustrating as a seller. I mean, it can take time, it can get annoying, it can become, don't call my baby ugly, prestige, and that's not a good way to get your company sold.
But that's heading to like the emotional part of it, because you need, as you said, you need to be prepared.
Yeah.
Because it's very hard. It's your baby, and if someone come and ask question, I mean, I would feel defeated and maybe very, very uncomfortable.
And even worse, somebody comes and asks you for this information, and then somebody else comes and asks you for the same information.
Yes.
And then a third party is calling you baby ugly. I mean, and you're trying at the same time. I mean, you need to run your business, right?
Yes, exactly.
Extremely time consuming and takes a lot of energy. So if you're already prepared and know the situation, it will be easier. You will know that this can happen. It will be normal. Then I need to talk to the buyer. We need to discuss the process, the timeline, what kind of resources you can provide and when. And then you can manage it much better and also impress the buyer. So the buyer will want to buy your company even more eagerly. So the win-win.
So it's better to be honest and transparent.
Yeah.
Much better.
Thank you.
Thank you.